Hello and welcome to the program. I am Imoni Amarere. The July 11 Supreme Court judgment, which granted financial autonomy to local government councils in Nigeria, has been dogged by all sorts of controversies, including how to give effect and bite to the meaning and to the spirit of that epochal judgment. The federal government, which sought and got the favorable judgment, has been foot dragging on its implementation, as it appears it was not ready for the turn of events. On the other hand, several state governments have been rushing to conduct the usual sham local government council elections in a bid to beat the possibility of zero allocation from the federation account. Yet, there are one or two states that are finding it difficult to come to terms with the finality of the Supreme Court judgment on the matter and are devising ways to either undermine or sidestep its full impact on fiscal federalism. It is probably in an effort to address some of the generated concerns that the federal government instituted a 10-member inter-ministerial committee to enforce the judgment. The committee also has representatives of state governors and local governments. But the question is this a necessary step in implementing a valid court judgment? Now, even as this is ongoing, concerns have been raised about the continued existence in the Constitution in Section 162, subsection 6, which established what is called state joint local government accounts. Or did the Supreme Court judgment automatically nullify that provision? If not, what happens to it? What other purpose is the joint account serving, since local government council allocations will now go to them directly? Will a formal amendment of the Constitution be required to bring it in line with the Supreme Court judgment? For these and many more issues we shall be looking at on the program today, as I'm joined by a panel of analysts to seek answers to some of these questions. First on my far right is Mr. Victor Patola. He is a convener, Lawyers for Civil Liberty. Thank you so much, Victor, for joining us. We're also joined by a former chairman of the Buhari Area Council here in the Federal Capital Territory, Mr. Musa Diko. Thank you so much.
Thank you for
joining us. And also joining us is Mr. George Itodo. He's a legal practitioner here in the nation's capital, Abuja. Mr. Itodo, thank you so much for joining us. All right, we'll go on a very short break. When we come back, we'll launch into our discussion straight away. Stay with us.
Of our dream, the Nigeria we need is the united, indissoluble, and cohesive Nigeria, which guarantees equity, fairness, justice, and prosperity for its citizens. That is our focus on people, politics, and power. It is fresh, insightful, impactful. It's a must-watch. People, politics, and power on AIT.
Thank you so much for staying with us as we take another look at the financial autonomy granted to local government councils by the Supreme Court judgment of July 11. How do we, or how does Nigeria give teeth and bite to that judgment? Let me begin with you, Mr. Victor Patola. Why do you think the federal government had to go the way of setting up an inter-ministerial committee to effect the provisions of that judgment?
Thank you. I think it's important that the federal government did what it did because the state government, they have, some of them, not all, have shown certain reluctance, to the implementation of the Supreme Court judgment. And let us also understand the fact that the allocation meant for local government authorities, these are funds that have been at the discretion, one way or the other, of the local government, of the governors of various states. So, taking this largesse away from the governors will not be easy or a child's play, as the case may be. So it is important that the federal government has taken it upon itself this initiative to ensure that it is not only enough that they will disburse directly to local government, it is also enough that they will ensure that there's implementation of this of the Supreme Court judgment. So
legally, can any individual or institution be reluctant to obey a Supreme Court judgment?
No, it is. It shouldn't happen. It shouldn't. But there have been certain instances where it's not only Supreme Court judgment, as the case may be. It's any court judgment, as a matter of fact. No institution, no government body should be reluctant to enforce any court judgment, as a matter of fact. But we'll also recall that immediately the Supreme Court gave its judgment, there are certain governors who were a little bit reluctant in regards to its implementation. Some governors even particularly said they will look for homegrown solution, for themselves in regards to the Supreme Court judgment. And it's not, some persons in their bid for ingenuity, they will want to circumvent one way or the other, around circles, around the judgment, looking for loopholes around the judgment. Okay, the judgment stated A and B. Okay, the government did not, and the judgment did not state A1 and B2. Maybe
all right,
find loophole
Mr. Kwatola, very quickly, let me let our viewers who are just joining us on our terrestrial transmission, free-to-air transmission, that we are actually looking at the Supreme Court judgment of July 11, which, of course, granted financial autonomy to local governments. And the move by the federal government of Nigeria to give teeth and bite to that judgment by setting up a 10-man interministerial committee. My guest right here in the studio, Mr. Victor Okpatola, who is a legal practitioner and convener of Lawyers for Civil Liberty. And I also have with me Mr. Musa Diko, former chairman of Buhari Area Council of the FCT. Thank you so much. And Mr. George Todo is a legal practitioner here in the nation's capital. Thank you so much.
Thank you for having me.
So you were explaining why it is impossible, in fact, out of the norm for any individual, any institution, government or non-government, to want to disobey a court order. But we have seen state governments and state governors express some level of reluctance and, in fact, criticized the Supreme Court judgment on that. Yes. What are the larger implications?
It's a dangerous dimension, where the Supreme Court of the land will make a pronouncement, a decision, a judgment, as the case may be, and due to your own interpretation or due to your own perceived, how do I put it, due to your own disposition, you feel the Supreme Court was wrong. Even if they were wrong, the argument is that you're a state governor, it's the state. You can always approach the court for a review if you think that's the way to go. But for state governors to come out and use certain words to derogate from the judgments of the Supreme Court is definitely unacceptable. And even apart from that, state governors looking for various ways to circumnavigate the judgment of the Supreme Court or run circles around it is also unacceptable. We understand that some state governors have expressly come out to express their reservation in regards to the judgment and use certain words such as they will find homegrown solutions in regards to the judgment. It's something that the whole of the country should take a stand against. We should be very cautious of setting dangerous precedents because we want to satisfy our own perception. The various government is known for choosing and selecting the judgment that they will obey, which is very wrong, which is a danger to democracy, a danger to rule of law, and very, very unacceptable.
Mr. Todo, as a lawyer, what's your take on that?
I think the setting up of the committee was more of finding a political solution than a legal solution. In a way of digressing away from my brother's point here is that the implementation of that judgment was not the responsibility of state governors. It was independent of their feelings, their opinion, or their criticism. It was the responsibility of the federal government to disburse directly to the local government. So I don't think there are ways the local government could have obstructed the implementation. Sorry, the state governors can obstruct the implementation. I think it's the president who is the chief executive of the federation as that's vested with the power to implement that judgment, because it's a judgment that mandating the federal government to pay directly to the local government. That probably, for political reasons, not legal here, because once there is a judgment, it ought to be implemented. Probably for political reasons, setting up that committee. Maybe because also the judgment itself has raised a lot of constitutional crisis. The judgment has caused a lot of constitutional crisis. The judgment has caused crisis between legitimacy and legality. Yes, the judgment is legitimate in the sense that it takes care of the yearning of the people. But that judgment constitutional? If you look at the express wordings of the Constitution, you say, no, this judgment is not constitutional. But is that what the people want? Does that judgment touch the popularity of the people's demand? Yes. Two, the last time while on air, I talked about the fact that the Constitution didn't give an identity to local government. Rather, created local government as an appendage of state government. If you go to the Constitution very well, Section 7, Sub 4, 5, then the fourth schedule, you understand the fact that even a local government is not even empowered to implement any project. They are only to participate in planning with State Economic Planning Board. They don't have the power to implement. If you send them this money as it is right now, they don't have the power to implement projects under the Constitution. Have you not created an issue? Because only the State Economic Planning Board has the power to carry out, implement, which they only participate. Have you not created a constitutional crisis? I think the judgment was not detailed enough to cure all the issues. I think it's more of a constitutional problem than a judicial interpretation.
Talking of legality and legitimacy,
yes.
Is the Supreme Court not also sitting as a constitutional court? Can it not make pronouncements that could alter provisions of the Constitution?
You have to understand that Supreme Court is not just a court of public policy, also a court of justice. Now, in marrying the two, sometimes they can interpret. No, the whole essence of Constitution and law is about the people. I understand the legitimacy of that decision. It's truly legitimate, and because it's legitimate, it's right. But if you test it with the provisions of the Constitution, you may not agree that that judgment is constitutional, even if they are constitutional court. But sometimes, remember, there are provisions for public interest. For the Supreme Court to give judgment on basis of public interest. But if you want to test the constitutionality of that judgment, that judgment does not agree with the Constitution. But that judgment is legitimately said that it agrees with the yearning and wishes of the people.
Which then brings me back to the point I asked, or the question I asked Victor earlier on. Should any individual or institution, government or private, have the authority to want to disobey a legitimate court judgment, a court ruling, a court decision, and most of all, a Supreme Court judgment that, by all intents and purposes, is final?
It's final. And because it's final, it's given constitutional clothing. So therefore, no one can disobey Supreme Court judgment. But the question where I a little digress is this. If there's an issue of disobedience here, it is not on the state governor, because they don't even have the capacity to disobey. Because the order was to the federal government, disbursed directly to the local government. In what way can a state governor stop that disbursement? It's become practically impossible for even a state governor to disobey. But if the federal government themselves are disobeying it, yes, that is where we now come. No, it is still wrong for the federal government to disobey. It takes nothing for the federal government to transfer that money directly. That's why I said I think they are rather looking at the political solution than the legal solution.
Mr. Diko, let me come to you as one who has been on the field as far as this is concerned. How far do you think that this interministerial committee can go in effecting the letters and spirit of the Supreme Court judgment?
Very far, and I think it's a very wonderful development that when you have a child that probably does not understand what you are telling him, sometimes you use cane, sometimes you involve the mother. Those are all part of finding a way to make the child understand you. I want to believe that the federal government must have looked at it just from the angle my two brothers here are looking at it. Over time, we have said the Constitution is sick. There are problems within our Constitution. It is unfortunate that the people that have the powers, that have the mandate to review this Constitution, does not listen and look in depth to the Constitution and what the people are saying to see how some of these areas that have problems can be attended to. But I think what the federal government has done so far is the best way to ensure that there is no unnecessary crisis between the state government and the local government because of the judgment by the Supreme Court. The Supreme Court, of course, is the final bus stop for all legal interpretations. And having done that at this stage, who else will be asking for interpretation? Now, what do we need? We need to apply discretion, which I said last time here, that probably the Supreme Court also applied discretion in passing their judgment, just like my brother here have said. Because when you look critically into the provisions of the Constitution, you will find out that the local government is just standing. When you look around the provisions of the Constitution as it affects collecting levies, taxes to ensure that funds are in the same cycle, you will find out that the state governors are just standing. So there is a need to apply dialogue. There is a need to apply what the federal government is applying now. The state governors come. Where are you not comfortable with the judgment the Supreme Court has passed? The local government come around. Where do you think will not favor you as well if the state government continue to be part of the resources that you are supposed to be attending to alone? So I think it's a wonderful area to see that there is no crisis as we go on. If the federal government had gone ahead to dispose this last month fund into each local government account, by now would have been another crisis between the state governors and the local government chairman.
What would have brought that about?
Good. In some states, we're still using what we call caretakers. That I think
And the Supreme Court judgment was very clear.
And the Supreme Court judgment is very clear because that caretaker position is not enshrined in our Constitution. I want to believe so.
Yes.
So continuously giving them fund to
guarantees
apply.
only democratically elected local government councils. Yes. So in other words, if the federal government was to disburse allocations, it would be to only local governments that are democratically elected.
So if they have disposed them into caretaker committees, how do you apply those resources? So I think the federal government has done very well. They have looked into what we avoid crisis. They have looked into what the state governors need to understand. That look, we cannot continue in this manner. Over time, we have blamed the system. The system is bad. The system has failed. Where is the system? Who has enacted this system? Who is applying this system? Who is implementing it? We, the Nigerians. So if the system here is ready and the people to implement the system are ready, why should we continue to prolong this? What the judgment has already brought to us on the table is to see that the system works for us. And I want to say, let the governors understand that this system that has been attended to this time is for the generality of Nigerians and for the progress of governance and government of this country. Look, last month's disbursement was for federal, state, and local government. The last week or last month protest was against the federal government for not providing good governance. Are the local government not part of governance? Are they not supposed to be providing good governance? Are the state governors not supposed to be providing good governance? Why only the federal government being attacked always? So this judgment is going to bring down a situation where now I and you will be ready to challenge the local government system, challenge the local government executive. What is happening? You have all our resources. You have all our taxes in your hands. We are not seeing development. Will he have an excuse to say the state governor has not given him money? Are we going to run to the state governor again to say, why have you not given this local government chairman money when we know that the money has been disbursed directly to local government accounts? Come on, let's help this system. Let's help ourselves. I think this judgment has come at the time that we need it. Because the country, we are tired of what people term as bad governance. And who are the people giving this bad governance? We, including myself. Including myself. If I am a local government chairman, or when I was local government chairman, if I never did what I was supposed to do, that was bad governance. If you're a state government or state governor, and you're not doing what you're supposed to do, that is bad governance. And I am a local. My access to government is through my councillor, to the chairman, from the chairman to the state governor, from the state governor to the presidency. And so it comes down that way again. So what are we saying in this judgment? We should be grateful to the federal government. If I expect by now, the local government administration or local government employees would have been giving Mr. President an award. So I want to say here, whether the constitution or no constitution, it is legal or not legal, it is standing or not standing, all we know in Nigeria is that Supreme Court is the final bus stop for interpretation of all laws. And they have done it.
So what happens now? I mean, since that judgment, no allocations have been made to local governments that are not democratically elected. What will happen to the funds that stand in the name of such local government when they eventually do have democratically elected councils? Will the backlog be paid, or what will happen?
I think at this point, that is what the federal government is driving at now by setting up this 10-man committee to look at modalities of what will happen to either the past or the present or the future. So I want to believe here that these resources already have gone down to state governors or to the local government account through the joint account. The monies are there because we have not had it on record that the money has been withheld. It is not official that it has been withheld. I have not heard it. So I want to believe that these monies have gone down there to continue the way it has been, pending when this committee will look into the modalities of transferring these monies directly to local government accounts. And subsequently, it will continue in that manner. We need just an understanding. And I pointed it out here sometime. I said, look, actually there is fear. There is fear, whether we like it or not. If you see the powers of local government in the Constitution against the powers of the governor, there will be fear. And that is why there is this fear.
They don't even have power in the Constitution.
They don't have power.
So is that fear responsible for, say, a state like Oyo State, where the local government chairman, the Argonne members of in that state decided to withdraw from Argonne and pitch their tent with the state government?
Well, I don't know if they are democratically elected. If they are, then I think probably ignorance of what they are doing. And if they are not, if they are caretakers, of course, who pays the piper, the tax, the tune? So if they are caretakers, the governor must have told them, look, if you continue with what has been given to you, I will bring you back home. And of course, nobody wants to come back home now when you have already gotten to the back of a horse. So I want to say here that, look, this panel, or I mean this committee that the president has set up is going to, by the grace of God, resolve these issues that the governors tend to have. Remember, it is not all governors that have said no. It is not. So if Oyo State, for instance, decide that they will not be part of it, in the whole of Nigeria, no. This dialogue that is coming, this committee that is coming, is going to give to him plain on why he should accept where we are. See, look, we are fighting insecurity in this country. And the problem lies here because our local government are not functional. Have you not been to states? Have you not seen where virtually 75% of citizens in a state lives at the capital of that state? What happened to the local government areas?
Insecurity.
Insecurity.
So
There is no governance. If there is government at these areas, the act of insecurity will reduce. Because there is no system that will say total elimination of insecurity. Because we are humans. We are dealing with human beings. Certainly somebody will be angry somewhere. Somebody will feel being cheated somewhere. Somebody will feel the only way I can get justice is to slap you. And once he slaps your brother, certainly there is going to be a problem. So the governor should look at it from this angle, that we need to get back on track. We need to see that people go to farm without hindrance. And when there are no government activities within these areas, even the lions will come around to chase you as a farmer.
So, Victor, let me use the expression of Itodo. How legal and legitimate is the action of the local government chairman in Oyo State?
Yeah, before I address that, although it is at this stage now, the Supreme Court judgment is final at this stage, But it is also important that we address certain things in regards to the Supreme Court judgment. I personally believe that the judgment of the Supreme Court is as clear as whistle. That's my belief. Because when you look at the Constitution, the Section 7, Section 162, when you look at the way all these provisions are cut, first of all, let me state that the provisions of the Constitution in regards to this local government, they are not drafted elegantly, in this sense that there's a part that gave powers in one instance, there's a part that withdrew that powers in another instance. So when you look at the gamut of Section 162, which provides for joint account and all these other things, first of all, one thing is certain in the Constitution. There is a provision for local government in Nigeria. So, as in there's a provision. The way the Constitution envisages it is by, okay, there is a federal government, there's a state government, then there's a local government. That is a given. So let me digress a little bit into federalism, the principles of federalism. A lot of persons have argued that given the principles of federalism, the judgment is wrong, which that's a lot of people have argued that, which I disagree with. Because when you look at federalism, what are the basic tenets of federalism? The basic tenet of federalism, first on the list, is division of powers, autonomy, constitutionality, and subsidiarity. By division of power, that means based on the tiers of government, there's division of power by the tiers of government. So all tiers of government have division of power. They have powers allocated to them under the Constitution. By autonomy, that means the powers given to them and other tiers of government cannot venture into that. So when you look at the arguments of federalism and these things that I've listed, which are which are not the form but are the substance of federalism, I will wager that those that are arguing that the way the Constitution is structured, the way federalism is all over the world, is that local governments are made to be subjected to state government. I will wager that they are equating or taking form above substance. Why do I say this? Once all these things I listed is fixed in a federalism, that federalism is federalism all over the world. The principle of whether or not a local government is subjected, infused under the state government, or the local government stands on its own, those are arrangements that differs by constitution of various countries. So what I'm saying now is that the fact that local government in Nigeria are not infused under state government does not make what we are practicing less of federalism. What I'm saying is, first, now that local governments are outside of state government, can we say there's division of power? Yes. Can we say there's autonomy? Yes. Can we say there's constitutionality? Yes. Can we say there's subsidiarity? Yes. Federalism is complete. Those are the substance of federalism. Any other argument that in United States of America, local government are infused under the state's government, in some other European
Canada, Australia.
local government are, that does not mean that any other country where local government is not infused under state government, they do not practice federalism. They practice federalism. So far, these things that I've listed are present. So the argument that the Supreme Court, what Supreme Court did was illegal. I had to bring this argument of federalism into it, because that is one of the grounds with which some people are arguing against the Supreme Court judgment. Then I am saying that the Supreme Court judgment is sound. Now, for instance, when we look at Section 162, Section 162 was emphatic. First of all, it said that this money is for local government. But that same section, the subsection,
Subsection 6.
made the state governor a trustee of local government money. That means this money is for local government generally, but it just merely makes them a trustee. When you look at the judgment, typically judgment of Justice Hagim to be particular, he stated it expressly that the local government, even previous judgment, that state governors are trustees of this fund. But given what has been happening over and over again, the state governors do not remit this money to local government chairman. And let us understand that if the Supreme Court had given, it is a basic tenet that the court will not give a judgment it cannot enforce. So if the Supreme Court have said, okay, state governors give local government chairman and local government authority or councils, give them their full money. Now tell me, how would Supreme Court have been able to enforce it without going a step further the way it did? We don't expect the Supreme Court to enforce judgment. So the way the Supreme Court went about it is constitutional, is legal, in my own opinion.
Okay, now that now takes us to the question that I asked earlier on about what happens to the provisions of Section 162, subsection 6. Because the Constitution clearly says that there shall be, each state shall maintain a special account to be called State Joint Local Government Account, into which shall be paid all allocations to local government councils of the state. Now the Supreme Court has directed that allocations be paid directly to local government. The provisions of this section of the Constitution, what happens to it?
Okay,
the judgment, by implication, nullify this provision.
Before I go into that particular, now when the Constitution said pay into the state joint account, the aim, the mischief, the aim of the Constitution is that this money gets to local government intact. When the Supreme Court said pay directly to local government, what is the aim? The aim is that this money gets to the local government intact. So the aim is still the same. That's the substance. The aim has been achieved, irrespective of the form, whether it comes directly through the joint account or it comes directly through the local government accounts that they will open, anytime soon, as the case may be. But in regards to this joint local government account, the National Assembly as the case may be, will have to amend that particular provision. The purpose of the court is interpretation of the Constitution. Their role is to interpret the Constitution. Their role is not only to interpret the letters of the Constitution, but also to interpret the spirit of the Constitution. As the case may be, the Supreme Court has interpreted the spirit of that particular section, which is that the spirit is that local government gets their fund intact. And the Supreme Court has done that in a very clear manner. So it is left for the National Assembly to amend the Constitution.
So an amendment is necessary.
Yes,
do you agree with that?
Let me just round up. Now, we must not toy with the ingenuity of the governors. we must not toy with their ability to make a, how do I put it, to walk around the Constitution. We heard Oyo State Governor when he said they will look for homegrown solution. When he said homegrown solution, what does that mean? It means they will find a way around it. We saw the actions of Oyo State local government chairman immediately afterwards. First of all, they left Algon. Secondly, you know, they started making certain moves to show that they're in solidarity with whatever positions the governor has stated. That is to tell you that the hold that state governors has on local government chairman in the previous dispensation, before this present dispensation, is still currently obtainable. So we must not easily do away with the capacity of state governors to find a way around, maybe politically or any other way, around this particular judgment in such a way that they will still go back to the old order, where local government chairmen do not have total control of the funds. And notwithstanding, as far as I'm concerned, I want local government chairmen to understand that it is their head that is on the spike. Because as far as this judgment is concerned, if 100 million, for instance, is allocated to you, it doesn't matter whatever way the governor is able to convince you to part with some of it. It is you that EFCC or ICPC, as the case may be, will be made to account for every kobo of that particular money. So it is now totally different from the previous dispensation. Now, it is out in the open that there's, you know, no way the government could, and the governor can make you part with that money. So anything that happens to that money is the head of the local government chairman that is on the spike. And apart from that, local government chairman should know that governors have immunity. They do not have immunity. If they do anything to infringe on this judgment, there are a lot of NGO part-time now making sure and dogging the legs of local government chairman to make sure that they follow the Constitution, that they follow the Supreme Court judgment, that they allow accountability. If not, they'll be going from office to court for criminal charges.
Mr. Todo.
Yes, on your question whether it requires an amendment. Yes. Community reading of Section 162, Section 7, and the 4th schedule of the Constitution shows you how naked the local government is.
What about the residual list?
Excuse me, sir. The residual list. What are the contents of that residual list? If you allow me land, okay. Allow me, I'll go there. Okay. Section 7 that created the local government. When it goes to the power of the local government, it's subjected to the laws of the House of Assembly. Which means the House of Assembly will have to provide for the powers, duties, and even the structures. The last time I said, the local government does not even provide for, the Constitution does not even provide for what we call local government chairman. It didn't even provide for what we called the local government vice chairman. You only say democratically elected, guaranteed council, guaranteed. It didn't provide for the structure. It didn't even provide for their power. It didn't even give them, provide for their executive power as it did to the governor and it did to the president. It made their power subjected to that, the laws of the State House of Assembly. How can it now function? How would you now tell me it's independent? Look at, go to Section 7. Subsection 4 and 5. 2, when it comes to economic implementations, that carrying out projects and the rest, he said their power then just to make recommendations to the State Economic Board. Not even local government economic board, the State Economic Board, which means a board set up by the state. Their duty is to make recommendations that relates to tax, development, and everything. How would you now say that same local government is not tied by the Constitution? If you talk about the residual list, that's why I wanted to direct him to the 4th schedule. You discover that whatever shall participate and make recommendations, shall consider and make recommendations to the State Economic Planning Board. Has that given it the power to implement? If not on this Constitution is holistically amended, giving them the power to carry out projects themselves. abolishing this so-called State Economic Planning Board. The local government have not been taken care of by the Constitution. Even the tagging of a local government chairman is customary, not because the Constitution even provide for, okay, the seat of a local government shall provide for that of the governor or the president. You know, democratically guaranteed democratic elected council. What about the structure? Who comprises the council? The leadership of the council. That's what we're talking about.
Yeah, because Section 7, subsection 1 says the system of local government by democratically elected local government councils is under this constitution guaranteed, and accordingly the government of every state shall, subject to Section 8 of this constitution, ensure their existence under a law which provides for the establishment, structure, composition, finance, and functions of such councils.
That's what we're talking about. It are subjected to the state. Then if you go to subsection 4 and 5, you find out that your duty there is to make recommendations to State Economic Planning Board.
That particular section does not go to the powers of the
functions.
Local government. Now, for instance, the particular laws you're mentioning, I actually understand that particular law, and I'm sure I've seen that of Lagos State to be particular. Those laws, I agree, stipulate.
Excuse me, sir. We are not. Don't subject. At that point, you are leaving it to the discretion of various state laws. We are saying no. Constitution, protect it yourself. Don't give it to state.
The fact that the state doesn't make it less of a law.
Advocacy at this point in time, but at the moment, this is what the constitution.
And it doesn't make it less of a law, does it? It doesn't.
No, it means that it can be subjected to the discretion of a bad leadership.
At the state level.
At the state level.
Okay. Now, the question is, Chairman, is this: these allocations will eventually go directly to the local government councils. At the state level and at the federal level, we know of a situation where budgets are made, are prepared and submitted to state assemblies, to the National Assembly for consideration and passage before implementation.
Yes.
I have never heard of such thing at the local government level. Yet they have legislative councils at the local government level. What will happen now that resources will go directly to them? Because what was happening in the past was that state governors and state governments were the ones giving directives to local government chairmen what to spend money on and what not to spend on. In fact, they employ workers for local government councils.
It is wrong.
What do we really want in this country? This word federalism, what are we really practicing federalism? Good. And if we are, what type of federalism? You see, America and Nigeria are two distinct bodies.
Yeah.
America brought a system that will suit America and the people. Nigeria is independent. We have a system that will suit us as well and the country. And if at this point, our federalism brings out the local government clearly, because that of America is silent.
God bless you.
That is what suits them. We have agreed and we have brought out administration of local government openly. What I think, like I've said, and I've always said, in my learned manner, that the knowledge I have about the constitution we have, there are problems. There are problems. For instance, the same constitution see you as an indigene of Abuja. The same constitution see me as an indigene of Abuja. But this same constitution does not see me as indigene of Ogun State. Because I'm from Abuja. Is there something not wrong? Now, we're looking at this area that we have to be applying discretion. We have to see how we bring out policies outside of the constitution to ensure that it suits the kind of people we have in Nigeria and the environment. And that is why I am supportive of what the president has done by setting up this 10-man committee. I wish he makes it 11 in the case of voting, but he had already made it 10. Now look, state governor. We have been practicing local government system, I think, far back as 1976. Are we going to now say today local government are not constitutionally guaranteed to implement or to carry out projects? The answer is no. So let's continue with what we have been practicing. If there are areas we think we need to look at, because the people that made this constitution are human beings. And this constitution was made at the time that they wanted what will suit them, either going out or coming in. And we are now saying today, we need some little adjustment. And I think that is why this moment we are, continuously the National Assembly is looking at some areas. I know between, I think, June, the issue of this local government now being responsible for carrying out the functions of primary healthcare delivery system, the primary school delivery system, and the rest of it.
Development of agricultural and natural resources.
I think it's now in the National Assembly legislative exclusive list. Because if you look at this same constitution, when it comes to providing primary health care services and primary education services, it only says local government shall be part.
God bless you.
It only says local government shall be part.
Participate.
And that they will participate. And that is why today, I want to say, we are on the streets almost every day to say bad governance. Bad governance. Bad governance is coming as a result of our constitution.
God bless you.
I may not be asking directly to have a new constitution, but I think there is the need to look into this constitution and see where we can amend to avoid these bottlenecks we have around us today. We are suffering because the local government are not functioning the way they should function. The administration of primary schools and provision of primary health care services are within the state. The local government are not even participating, like the Constitution said, as the state. But I think from the ground here in the Federal Capital Territory, we are fortunate, I've always said. Because I remember 3 days ago, during the ministerial briefing of the FCT minister, he did say they are carrying out some projects to ensure rehabilitation of about 20 schools within the Federal Capital Territory. And he said, even though it is not the responsibility of the FCT, but the local government. And here we have a local government that does not have the mandate to provide primary school education. Instead, they only pay the staff salaries of primary school teachers.
Okay.
So at this point, these resources that are here handy, I think we should be able to go along the way we have been going. The state governor should understand that in this committee, they are going to discuss the modalities that will suit every tier of government. And let us at the grassroots begin to feel good governance, begin to see what we're supposed to have, and stop us from going on the streets. Look at the last protest. Thousands of infrastructure were destroyed. Economy fell worst, even when it was worse, we said. So we can't continue in this manner. So I may be speaking differently from what the legal brothers here are trying to interpret, but I must also as well say to them that whatever thing they interpret today, the Supreme Court judgment
has given its
I've given it
has
final.
taken position.
Yeah, a man from the grassroots. All right,
Just,
gentlemen, thank you so much. Just 60 seconds because we have to go.
Yeah, my joy in the Supreme Court judgment is because many attempts have been made to amend this constitution have been frustrated by the State House Assembly, even when they wanted to give them independence. This is just the best shot the Supreme Court shot. But as a lawyer, I was just trying to analyze between the express provision of the constitution and legitimacy. Legitimacy, yes, it is accepted, that's what the people want. For that, it is lawful, it is binding, it is final.
Thank you so much. Thank you so much. Victor?
Yes. Right now is the time for National Assembly to amend the Constitution suitably. And also, local government chairmen, local government councils should take initiative. There have been a lot of aberration practiced in the name of federalism previously. For instance, the budget you mentioned earlier on, these are things that local government ought to do. They have their own they ought to be able to pass their budget. So National Assembly should be rigorous and look into all these things. And also, local government chairman, local government council should be ingenious and bold. The Constitution, the Supreme Court judgment has favored them.
Okay. Thank you so much. Victor Patola is convener, Lawyers for Civil Liberty, and he's been joined by Mr. Musa Diko, former chairman, Buhari Area Council here in the Federal Capital Territory. Thank you so much. And Mr. George Todo, He's also a legal practitioner based here in the nation's capital. Thank you so much.
Yeah, thank you, sir.
Thank you.
Well, that's our program for today. Please join us again. We'll bring you a fresh edition of People, Politics, and Power. Bye for now.
Of course.